So good afternoon, everyone, and welcome to our MVLS's third Thursday training. I'm going to let some people enter into the webinar before we actually get started. So I still see a few people trickling in. So maybe we'll let it run to 12:03 before we get started with the presentation. All right, so we're going to get started. Welcome, everyone, and thank you for joining us. My name is Asia Mallory. I'm the Consumer Staff Attorney at MVLS. Today, we have Mr. William Steinwedel presenting on the intersection of bankruptcy and foreclosure. So, Bill, whenever you would like to get started, you may.
Hello, everybody. My name is William Steinwedel, and I'm the supervising attorney for the Foreclosure Legal Assistance Project at the Maryland Legal Aid Bureau. I've also been doing bankruptcies for over 10 years now. Saying that makes it feel like a really long time. So I hope to share my knowledge of these two topics, and please ask questions as we go through, because some of the things we're going to talk about are a little intricate and detail oriented and a little complex. So I want to make sure that I'm not talking past anyone, because I've been doing this a very long time, but for others, this might be totally new. So I want to make sure that everyone leaves here with at least a decent understanding of the basics. So the question is always, when is a bankruptcy a good option in a foreclosure case? And we're going to go over that. But first, I think it's important to understand that even before you consider that, when can you file a bankruptcy to have any tangible effect? So if for a bankruptcy to stop a foreclosure sale, it has to be filed at least 1 minute before the scheduled sale date. So for instance, if there was a scheduled sale date for tomorrow, you would have at 9:30, you would have to file the bankruptcy, and there would have to be date stamped or internet proof that you filed the bankruptcy at tomorrow at 9:29 or before. If the foreclosure is filed after that, it technically does not put the stay in place. So the property sale has happened and they can move forward. That's why it's critical. So if a client tells you that they have a sale date in 5 days or 10 days, that's your drop dead deadline. You have to get everything ready by that point. If you don't, then there is not going to have any tangible effect. There is something called a bare bones bankruptcy. I generally don't recommend filing those because they can cause issues down the road, but there is a certain minimum that you can file for bankruptcy to impose the stay, which would be a list of creditors, the credit counseling course, the voluntary petition, and the filing fee. But I generally urge that you get as much together as possible before the actual sale date. so that the filing is strong and it looks plausible before the sale date begins. So when will a bankruptcy not stop a foreclosure sale? This would be if you filed it before a actual sale date. So there is another caveat. So a person can generally, there are eventually limitations at the far end, but generally a person can file as many bankruptcies as they want. As long the problem is that you only get one stay per calendar year, and that's the critical thing in a bankruptcy is the stay, because the stay is what keeps the creditor from being able to execute on the real property or collect against the debtor. So if your debtor has filed one bankruptcy in the previous year and it's been dismissed, then under 11 U.S.C. 362 C3 of the United States Bankruptcy Code, you have to file what's called a motion to extend the automatic stay. And you have to do that within 30 days of the original filing. If you do not do that, the stay will automatically be lifted after 30 days. Or the creditor could file a motion to lift the stay and it'll generally be granted. So in that case, you have to make sure that you file this motion basically with the filing, because you have to make sure that you get an order from the court as soon as possible. Now, if your debtor has filed 2 or more bankruptcies that have been dismissed in the last calendar year, there is absolutely no stay whatsoever. And I've probably done this maybe 5 or 6 times. So you have to file with the motion, you have to file an emergency motion to impose the automatic stay, which will automatically go to a hearing immediately before the sale. In addition to that, you have to file a motion to shorten time, just like you do in state court, to shorten the time of the response of the creditor so that they can have time to respond before the actual sale occurs and before the hearing occurs. So those are 2 important caveats. In addition, if a bankruptcy was dismissed, if your client filed a previous bankruptcy and it was dismissed as a result of a lack of filing the proper paperwork or the result of a motion for relief from stay, then the person is not eligible to file another bankruptcy for 6 months. Now, if in the first case they weren't represented, and in the second case they were, you may be able to get around this with the motion to extend the automatic stay, but I just want you to be aware of this bar. The most important time this comes into play is when a motion for relief from stay was filed in the previous case, because the idea is that the debtor should not be able to get around the motion for relief from stay that was granted on the behalf of the creditor because of dismissing the case. So that's the reason that bar is in place. So what are the types of bankruptcy and we're going to talk about these more as we go through, but I just wanted to know briefly what the language used in the bankruptcy court is. So there's 2 different types of bankruptcy. There's a Chapter 7 bankruptcy that's called the liquidation bankruptcy. There's a Chapter 13 bankruptcy, and that's called either wage earner or personal reorganization bankruptcy. Either bankruptcy will stop a foreclosure sale, but generally a Chapter 13 is more useful, as you can cure, and we'll talk about this more later, but you can cure mortgage arrears in a Chapter 13, which you cannot do in a Chapter 7. Okay, so Chapter 7, this is the basics. I don't want to go too much into this. This is not a bankruptcy training, nuts and bolts, which, by the way, MVLS has, if you're interested in learning more after today. But I wanted to give you at least the basis. So Chapter 7 is a liquidation bankruptcy. And what that means is that basically you're liquidating your non-exempt assets to sell to your creditors. So in the state of Maryland, there's a certain amount of assets that you can exempt that are exempt from collection for your creditors. But anything above that has to be sold for the benefit of your creditors. Generally, most of the assets that low-income clients have, which is a majority of the people that are represented by MVLS and Maryland Legal Aid, are exempt. And most cases are what are called no asset cases. So if there's no assets, then they don't have to get, they just get a discharge and they don't lose any of their own personal or real property. However, the stay in a Chapter 7 is only about 4 months. And if the creditor files a motion for relief from stay, that stay can be lifted almost immediately. So if the homeowner is not making their mortgage payments. So a Chapter 7 only works either, and we're going to talk about this more, either if the goal is to sell the property and that there really isn't any realistic chance of saving it, or if something else like the homeowner's assistance fund or a loan modification is in the works and you just need to buy a little extra time to see these actions through. When is a Chapter 7 a good idea to avoid a foreclosure? Again, generally, Chapter 7 is not going to help much with a foreclosure because you cannot cure mortgage arrears through a Chapter 7. But there are a few exceptions. First, under Maryland law, a homeowner can only exempt about $32,000 worth of equity in their house. Anything above that, the trustee in a Chapter 7 would have to sell the house for the benefit of the creditors. So if your client has home equity greater than $50,000, just generally from what we've been told is sort of where the trustees, because there are fees associated with selling a property. That's usually the cutoff. And they know that they can't save the home, as in they have no income, or they have very limited income and the mortgage payment is rather high. They've come to the conclusion, or that for other reasons, they've come to the conclusion, I just can't save this house. They can file a Chapter 7 and have the trustee sell the property. Basically, the trustee can sell the property. The homeowner gets their exempted equity plus any additional equity after all the creditors and the trustee is paid. So for a homeowner who's moving on, they can walk away with, 30, 40, 50, $60,000. That can be very helpful for the next steps, whatever they are. About 5 or 6 years ago, this wasn't this wasn't an option for most homeowners because home equity was usually below what it was owed on the mortgage or about what was owed on the mortgage. But in the last couple of years, as home values have skyrocketed, this has become a better and better option for homeowners that realize I just can't keep this house. So as I said, I think in my career, I did like 2 or 3 of these for like 6 years. And probably in the last 2 years, I've done like 3 or 4. So, I mean, it doesn't work for everybody. A lot of homeowners, don't want to lose their home and don't understand the reality of the finances. But it is an option that exists. So please keep it in mind. Second, if the client is a good candidate for a homeowner's assistance fund or a loan modification, as I stated before, Chapter 7 may provide a homeowner a little extra time to get through these programs, because sometimes these programs take time. However, if this is the goal, then you need to be either assisting the client with the modification or making sure that they're getting assistance from a housing counselor or someone else with the modification or application, because the time is very, 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 very short. So this was what I was speaking of in the Chapter 7 sale bankruptcy. Under Maryland law, the homeowner can only exempt about $32,000 worth of equity in their home. If the equity is significantly greater than that, they can file Chapter 7 and the trustee will sell the benefit of the home the home for the benefit of the homeowner and the creditors. The homeowner would get the exempt equity plus extra after the trustee, mortgage company, and other creditors and realtor are paid. Again, if the homeowner understands that there really isn't a realistic chance they can save the house, this is an option. Now, what you might be asking yourself is, well, why wouldn't they just sell it outside of the bankruptcy and then they wouldn't have to pay the trustee at all? They could control all of the costs. Well, there's 2 reasons why you might have to go in this direction. The first one is if there's a foreclosure sale pending within the next 2 weeks. Some people don't realize, but a sale is not loss mitigation. So the mortgage company is under no obligation to stop any sale just because you're trying to sell the house or your client's trying to sell the house. So you may need the Chapter 7 to stop the foreclosure, which it will do, and allow the sale to happen. The other reason is that from my experience, a lot of the homeowners that are lower income have a lot of additional issues going on. Like, there may be hoarding going on, there may be, family issues, they may be health issues, there may be other things. So if you file a Chapter 7 and allow the trustee to sell it, yes, it does cost your homeowner maybe a little bit of money, but it takes all the responsibility and puts it on the hands of the trustee, which takes an emotional burden off of your client, which can help a great deal. Because my guess is if a client has gotten into the position where there's a lot of equity, but they haven't moved, and a sale date's either coming or it's already set, then the chances are there's something else going on that is preventing them from moving forward, and maybe putting it in the hands of the trustee is not the worst option available. So now we're going to move on to Chapter 13, which is going to be more of the meat of what we're going to talk about today. A Chapter 13 is known as the wage earner or personal reorganization bankruptcy. Basically, a Chapter 13 for an individual is the same thing a Chapter 11 is for, or a small business Chapter 11 is for a business. It's the same. I mean, there's a lot of differences, but it's the same idea: is that you can reorganize your debts, pay your secured creditors, pay other creditors, and avoid the consequences of lost property, which would be like a foreclosure or repossession, and it's the same thing. In a Chapter 13, the debtor has to pay back their creditors either in a 36-month or a 60-month repayment plan. If they fail the means test, it has to be 60 months. If they pass the means test, it could be either 36 or 60. Although you may want it to be 60 because that'll make the plans, because if you're trying to save the home, that might make the plan payment lower, which would make it more likely that the debtor could succeed. In addition to having to pay back the arrears on the mortgage, there are certain things that every debtor has to pay back regardless of what their income is if they want a confirmable Chapter 13 plan and to receive a Chapter 13 discharge. The debtor must pay back all non-dischargeable income taxes, federal and state. Now, the basic rule is if they've been assessed within the last 3 years, they're not dischargeable. Now, it does get a little more complicated than that, but again, this isn't a bankruptcy case. This isn't a bankruptcy training, but that's the basics. Basically, if they have been assessed within the last 3 years, generally they're not dischargeable. In addition, if the homeowner or the debtor has domestic support obligations, child support and alimony, then they must be cured through, and there's defaults on these. Those defaults must be cured through the plan as well. And they must pay all pre-petition defaults on the secured debts, which is the mortgage arrears that we explained. The debtor must also, this is where it gets tricky because the debtor might think, oh, I can just pay $500 a month. But in addition to that, they must also pay adequate protection payments on all secured property that they're retaining. Basically, this means that in addition to the trustee payment of whatever amount that is, they have to also pay the mortgage payment, the regular monthly mortgage payment. This is why steady income is an absolute requirement for Chapter 13. If your client's income is not steady, it's going to be very hard for them to succeed. We're going to talk more about the calculation in a second. But what you want, ideally, is, and I'm not saying I haven't filed cases that were closer than this, but ideally, what you would like for a Chapter 13 to succeed is for the debtor's income to be about twice as much as the mortgage payment. That probably leaves enough room, although it's always going to be difficult, but that probably leaves enough room for them to make the trustee payment, make the mortgage payment, and make their basic utilities and living expenses without running into a serious problem. Now, there may be change. Obviously, that's not an absolute. If a person has a very large car payment or other things that may cause a problem, that may not work. But that's sort of where I look the basics. I'm not saying there isn't other situations that I've filed cases, but the slower and lower that number gets, when you start getting to 60%, 70% of the income being the mortgage payment, the harder and harder for a Chapter 13 to succeed it becomes. And it's important to remember, although this may have changed after COVID, just simply because there aren't as many Chapter 13s as there used to be. But the failure rate in Chapter 13 was about 80 to 85% nationally, either that it had failed and it was dismissed or that it was converted. So they're very hard to get to work because, again, it's a 5-year plan and a lot of things can change in 5 years. So that's why it's important to, at the beginning, to be realistic about the chances of long-term success. It looks like we have a question. So it would be, so double, basically, if a mortgage payment is $1,500 a month, you want the homeowner's income to be about $3,000 a month. You want it to be about twice as much as what the mortgage payment is. Again, that's usually or more, but that's at least what you want. That doesn't mean that you can't do it when it's tighter, but the tighter it gets, the harder it becomes. So when is a Chapter 13 a good idea to avoid a foreclosure? So if there's no sale date and you still have the options of things like mediation or loss mitigation, loan modification, or half applications, you should try those first because generally over the long term, they're more likely to succeed. And also it cures the issue faster. You don't have to wait 5 years to cure the issue. And you're not in a 5-year basically look at your finance, a 5-year look at all of your financial assets and liabilities. So it's generally better to avoid, but sometimes it's not avoidable. The other thing you have to make sure is that there's limited equity in the property they're trying to save, or because the more equity you have, and this is something that's called the liquidation test, the more equity you have, the more you have to pay to unsecured creditors, and the higher and higher that trustee payment gets. There's also some people, and I've represented a lot of them over the years, which is one of the worst stereotypes, I believe, of people that file bankruptcy, especially in the low income end, is that they've run up a lot of debt. Actually, some of the clients I've represented have far better credit scores than I do, and most of the people I've seen, they have literally no debt. So that allows, so even if they fail the liquidation test and they would have to pay a lot, because there isn't a lot of debt to pay, the plan is still workable. But you have to look at that. You have to look at a person's credit report. You have to look at the equity in the property before making that decision. The other thing that a Chapter 13 allows you to do, and we will talk about this more, is it allows you to avoid second mortgage liens or HOA liens if there's no equity above the first mortgage. So this is extremely helpful to our clients and to everyone. So if a person has a second mortgage lien or an HOA lien, even if they don't have a lot of mortgage debt arrears, or if they've cured the arrears through a half program or a loan modification, a Chapter 13 may still help because it would allow them to get rid of these other problems. Again, as I talked about, the steady income that would allow the homeowner to save the property and afford a trustee a mortgage payment. Again, they have to pay the pre-petition arrears and the regular monthly mortgage payment. That's not an easy thing to do. So that's why it's so critical to figure out what the income is, how consistent it is, if there's any tax issues. That's another thing. If the person is self-employed, they may have to set up what's called quarterly tax payments because they're not having taxes withheld from their paycheck. That's why it's hard for people that are self-employed to work in a Chapter 13. It's not impossible, but it does take some tax planning and some business planning to allow that to work. So if it's your first Chapter 13, you may not want to start with a person that's self-employed. So how a Chapter 13 works in a foreclosure case. So the first thing you do is you meet with the client and you prepare the bank's schedules. And the way you do that is by getting their financial information, the bank statements, the tax returns, their credit report, their income statements, pay stubs, and basically you want their whole financial picture. And you basically put that all in, and the software, there's either Best Case, there's also SynCompass, there's a lot of softwares out there. There's I forget, there's another one that's big, but there's several softwares. Basically use that to develop the schedules. Then you develop a Chapter 13 plan where you make sure you pay everything at the floor, the DSO, the taxes, the mortgage arrears, and you make it as low as possible, but still paying everything you're required to pay. And then you file the case, and after you file the case, they'll schedule a meeting of creditors. Meeting of creditors are all done virtually. Now, unlike a Chapter 7 where there's about 15 to 16 trustees, in a Chapter 13 there is only 3 that if you file the case in Maryland that you can get. Brian Tucci handles the cases in Baltimore. Timothy Brannigan handles the cases in Greenbelt, and Rebecca Herr handles about half the cases in each of the jurisdictions. So that gives you an idea. So it's not going to be like you're always working with the same people in a Chapter 13. So that's why it's so important to make sure you know what you're doing before you file a case, because it doesn't take long to get a reputation of filing things where things are missing. and other things. So again, if you need help, my email is going to be at the end of this presentation, and I'll put it in the chat as well, because I'd rather help somebody in the front end so that they don't get the reputation of filing cases with missing documents or missing information. All right. So we're going to do two examples. I know some people become lawyers so they don't have to ever do math again, but unfortunately, and really the software will do a lot of this, but just like anything else, it's like if you're using a calculator, if you put the wrong numbers in, then you're going to get the wrong answer regardless of, it's only a tool, just like the software is only a tool. So you have to know what the numbers mean that you're putting in there so that you can get the right answer. So in this case, this example, the homeowner has about $25,000 in arrears and $3,000 in IRS tax debt. They don't have any equity. They don't have any other things that need to be paid. So, you have to pay the arrears and the IRS debt. In addition, you have to pay a trustee fee of 10% of what's paid to the creditors. So if you add 25,000 plus 3,000, that's 28,000. 10% of 28,000 is 2,800. And then, so the total amount that has to be paid. So the total amount that has to be paid through the Chapter 13 plan is about $30,800. If you divide that by 60, you get about $514 a month in the trustee payment. So that's one example. Another example, I'm going to make this one a little more complex. So in this example, you're going to have about $20,000 in arrears, $5,000 in state of Maryland tax debt, and there's $3,000 worth of equity in a house that you have to pay for. So if you add, $7,000 worth of equity in the house. So if you add 20,000 plus 5,000 plus 7,000, you end up with 32,000. The trustee fee on 32,000 is 3,200. So that you end up with 35,200. If you divide that by 60, you end up with about $587. So again, this is just an idea of how you develop a Chapter 13 plan. And while you can step up payments, it's usually best to try to make the payment as consistent as possible, especially when a person's low income, because it's so tight of a budget to begin with. The client will say, oh, I could pay more in 3 months or 6 months. And then you get to 3 months or 6 months, and a lot of times they'll be, oh, I can't pay more. So that's a problem. The other thing is, so in most Chapter 13 cases, a homeowner who receives a tax refund, that tax refund has to be paid has to be given directly to the trustee every year that they're in the case. However, if you prorate the tax refund on their income schedules, which basically means make it part of their income, their monthly income, then they don't have to do that. And that is especially a good idea with a low income client because of the earned income tax credit and other tax credits like the child tax credit. The tax refund is a very important part of their monthly and yearly income. So turning that over would not be something most of our clients could afford to do. So I strongly urge you to prorate in every case that you file, but especially if the person is low income. So now we're going to talk about some of the things that you can do in a chapter 7 or a Chapter 13. I'm sorry, some of the things you can do in a Chapter 13 that can make the case worthwhile and also improve your client's financial situation. In a Chapter 13 case, you can file what's called a motion to avoid a lien under 506 United States Code 506A, which is either a second mortgage lien, an HOA lien. There's other liens like water bill, like water utility liens, things like that. So you have to demonstrate that the property value is less than the balance on the first mortgage. So basically, If the property value is only, let's say the mortgage balance is $325,000, but the property value is only $300,000. So every lien above that first mortgage becomes avoidable because of the mortgage being greater than the value of the house. And basically what happens is those second liens become unsecured and dischargeable if you complete a Chapter 13 plan successfully. So that's the other thing. Just getting a case confirmed and a motion granted does not in itself make the lien go away. You have to complete the plan successfully and receive a discharge. If you do not do that, the lien basically snaps back into place. So that's a very important thing. Some new filers do not understand that just because the motion is granted doesn't mean the lien's automatically gone. Unfortunately, this is a lot harder than it used to be because property values are going up at such a rate as they are right now. Unfortunately, this used to be a lot easier, but it's now become quite a lot harder. And there are a few liens that can't be used for: mechanics liens, attorney's fees liens, and tax liens it cannot be used for. The reason why it can't be used for tax liens is because tax liens attach to every piece of property a person owns. So it not only attaches to the home, it also attaches to your couch, your chairs, your computer, your cars, attaches to everything. So you can't avoid the lien because the lien attaches to everything. This can be kind of complicated. Again, I'm going to provide my email address at the end of the presentation. If you have any questions, please let me know. Also, if you can get some kind of appraisal or market analysis on the property, it is generally helpful. So there is another thing that you can do to avoid liens, another type of lien. It's the motion to avoid lien under 11 U.S.C. 522. This can actually be done both in a Chapter 13 and a Chapter 7. It can only be used to eliminate judicial liens. There is some other lien it can be used to avoid. It's something called like a non-possessory lien, but those things have gone. I've never done one, and I've been doing this for 10 years. They used to be kind of common, like you used to use like your couch as collateral if you bought a piece of furniture or something. But I've never seen one, and I'm not going to talk about it because I don't think it ever happens anymore. So the judicial liens are really what this avoids. You have to demonstrate that a judicial lien impairs an exemption a homeowner could claim on their home if the lien wasn't in place. So like, let's say they had $20,000 worth of equity, but they have a $3,000 judgment lien from state court. So they would show that they could have claimed $20,000 as an exemption, but they can only claim 17 now because there's a lien in place. So that lien should be lifted. You have to receive some kind. Now, unlike the other case where you have to receive a Chapter 13 discharge to avoid the lien under 506, under 522, you have to receive some kind of bankruptcy discharge. It can be a Chapter 7, it can be a Chapter 13, but it has to be some kind of bankruptcy discharge. So this is the path to confirmation in a Chapter 13. You file a bankruptcy case. You go to the meeting of creditors. You fix what's required. The trustee requires you provide the additional documents the trustee is requesting. And the client pays on the Chapter 13 plan timely. I can't tell you how important this is. You can do everything right. You can provide all the bank statements and all the tax returns and all the proof of income. You can do your motions to avoid lien. You can do everything right. And then you get to the confirmation hearing and you email the trustee, and the trustee's like, well, you've done everything right, except your client's $2,000 behind. If they don't pay, everything else becomes meaningless because they've not shown that the plan could work. So that's very important. The good thing is all the trustees now offer an ability to pay online. So you no longer have to send the payments to the post office box in Memphis like you used to. You can still do that, but you don't have to do it anymore. So then you have the confirmation hearing. So with Trustee Tucci and Trustee Herr, you basically email their offices about 3 to 5 days before the hearing saying, if they haven't emailed you already, saying, are there any issues, that we need to fix for the confirmation? And then hopefully you can fix everything, or they agree to a continuance if you need more time to fix things and something like that. Unfortunately, Ms. Trustee Brannigan only allows you to call his office between 1 and 4 the day before the hearing and discuss the case with him. That's his policy. That has not changed to my knowledge. So that's what you have to do. And then hopefully you're able to work things out. If your case is called, most of the time that means there's something seriously wrong with it. Usually it's that your client hasn't paid, or that there's some major issue that it, because you ultimately the trustee is not the judge. You can argue your case should be confirmed, but that's a very uphill climb. So if your case is called, that usually means there's serious problems with the case. In addition, you do have to provide documents to the trustee before the meeting of creditors. Usually it's bank statements, income, and that might be covered later. But I just want to let you know all the trustees now have electronic upload. You used to have to mail them, but you don't have to do that anymore. All right. Motions for relief. And again, there is, I was told by MVLS, there also is a presentation on the nuts and bolts of bankruptcy where they can talk about uploading documents and things of that nature. Motions for relief from stay. A motion for relief from stay is basically filed generally when the debtor doesn't pay the mortgage payment, the regular monthly mortgage payment, while they're in bankruptcy. So now the trustee, the creditor can say, well, you don't have the right to this stay anymore because we're not being adequately protected by the bankruptcy. We're not receiving our monthly payments. So this stay should be gone and we should be able to move forward with a foreclosure or any other kind of collection action. The most important thing here is to file an answer. I cannot tell you how important this is. Do something. Even if you can't get a hold of your client, file an answer and say, I can't get a hold of my client, but I'm continuing to work on this issue. Because the reason is twofold. One, because once the stay is gone, the case might as well be gone. Because if you're using it to save a house, once the stay is gone, there's really no longer much of a point to the case. If you don't, the other reason is if you don't file an answer, the motion can automatically be granted without a hearing. The only way you get a hearing imposed in the case is by filing an answer. I'll never forget, this was one story. This happened about 5 or 6 years ago. And I had a case that had a lot of issues with it, but I had filed an answer and I was going to fight it in court. And this attorney came from some very big law firm. I wouldn't mention it even if I knew, but I don't remember what firm it was. And I mean, he was, Armani suit, $10,000 suit, while I walk in with my $200, Joseph A. Bank suit. And he goes, and we're just sitting there and the judge's clerk goes, Mr. Smith, that wasn't his name, but Mr. Smith, why are you here? He goes, well, I'm here to defend my client, blah, blah, blah. Mr. Smith, you didn't file an answer, so there's no hearing for you to be here for. So I think you need to go have the discussion with the client. So that's how important it is to file an answer to these proceedings. In a Chapter 7, you can really only delay the lifting of the stay because the stay is automatically lifted once the case is over and discharged. So basically, you can only delay it a few months. So that's why it's so important to immediately work on a loan modification or half application if that's the goal. The options to resolve it in a Chapter 13 are you can file a motion to modify, which we're going to talk about a little bit more, and do a consent order where your client pays back a little bit extra over 6 to 9 months. That's generally not a great solution for a foreclosure, for a mortgage, unless it's only a couple months due, because the mortgage payments are usually so high. But for something like a car or an HOA, that's generally a better solution than trying to modify the plan, because blowing up a whole plan to fix an HOA or car debt is not a great idea. An affidavit of default is what, so basically a motion to modify plan is basically you go through the whole confirmation process over again, you propose a new plan, and you hope to get the court's approval. You can extend the terms of the plan from 60 months to 60 months after confirmation. So let's say, for instance, it took 6 months for your case to get the confirmation. you can file a motion to modify where it's 66 months instead of 60. You used to be able to extend it to 84 months under the COVID relief, but that was repealed in March of 2022. So that is no longer an option. An affidavit of default is if your client's defaulted again after you did a consent order or motion for relief from stay. They usually get 2 of these before the creditor just moves forward and says, this isn't going anywhere. The homeowner does have the ability to cure default. It's usually between 10 and 12 days. However, if you file an answer, you can extend that. But unfortunately, generally a modification is not an option. A second modification is generally not an option in this situation. So so your client really needs to come up with the money faster. The case is going nowhere very fast. And by the way, I did want to note that a bankruptcy can be filed in both a reverse mortgage and a standard mortgage situation, standard 30-year mortgage situation. And a trustee's motion to dismiss, basically this is if the debtor doesn't pay the trustee. If they have a trustee payment and they don't pay it for some period of time. Now, if your client is working a standard W-2 job, generally the trustee will issue what's called a wage garnishment and take it automatically out of the check, which does help avoid this, although your client's not going to be happy, but it does help avoid this eventuality. Again, the debtor should file an answer. You can also file a motion to modify, similar to a motion for relief from stay. One thing I will say is the trustees are generally more understanding. They generally give you more time to resolve the issues for 2 reasons. One, because the trustees are generally very nice people who I have a good relationship with, and a lot of lawyers have a good relationship with. But the other reason is a more practical one, that if a case fails, they also stop getting paid, because remember, they're getting paid out of the 10% fee in the plan payment. So if they're not getting paid, if the case doesn't work, they lose out too. So it behooves them to try to make the case work if possible. So the one thing about representing lower income people in Chapter 13s is we do a lot of what the dearly departed Judge Manis, who used to be on the bankruptcy court, he has since passed away, used to call a bumblebee plan. The reason it's called a bumblebee plan is that if you look at a bumblebee, he's kind of a little fat, bug or insect, and it's got very small wings. So if you look at it, it really physically shouldn't be able to fly, but it does. Why? I don't know. And that's sort of the way a lot of plans work when you represent somebody who's low income. If you look at the math, realistically, it doesn't look like it'll probably work over the long term, but it works. I've had clients do amazing things. But the reason why I bring that up is because it's a struggle. It's a daily struggle. It's a monthly struggle. It's a weekly struggle, yearly struggle to make it work. So that's why if you represent lower income people, you should continue to work on loan modifications and homeowner assistance fund applications as long as that's available, to try to get them out of the Chapter 13 that would allow you to convert or modify to a lower payment. It's very, very important to never give up. Because while you may say, well, they were already denied, but sometimes if you wait 2 or 3 years, the decision changes. The servicer, a lot of times these loans are sold and a new servicer has a different opinion. So never give up hope. I'm not saying you should file loan modification 60 times, but if the servicer's changed and your client's struggling, it never hurts to try. So after you get a loan modification or you get the homeowner's assistance fund, the one thing is if you're applying for half, you do have to file a motion with the bankruptcy court. I have samples if you run into that issue, and I'm going to bring my email address. You have to file a motion, or you have to apply for the half, or if you get a loan mod, you have to file a motion to modify the secured debt. And this is important, because not so much from the bankruptcy court, because they don't really care. They're very happy. They'll just grant the order. It's more of an issue from the state and the mortgage servicers. They'll say, we can't move forward until we get some notice from the bankruptcy court. So that's why it's so critical. Options for a bankruptcy after a loan modification. You can convert to a Chapter 7 if there's no unexempt equity. You can modify the chapter plan down. This is usually a good idea if you strip the lien, because you can't, if you convert to a Chapter 7, the lien springs back. So you want to keep them in a modified plan, but you can modify it to a smaller amount. Or you could just dismiss. I generally don't advise this, but I have done it before on a couple of occasions for various reasons. I mean, usually if your client's devoted this much time, it's good to get something, but sometimes it just doesn't work mathematically. All right, so that was bankruptcy and foreclosure in 45 minutes, which is a lot of information, which is a lot of information. But so now I'm here to answer any questions that you may have. So it looks like people are either really confused or really bored. I don't know which one.
Yeah, I am not seeing any questions in the chat or in the question and answers box, but are people free to email you?
Yes. Let me put my email in the chat. That way everyone has it. So that's my email address. Email me anytime, any questions that you may have.
Well, so since I do not see any questions in the chat or in the question and answers box, thank you. Oh, yes. So there is a question. So MVLS has a intro to chapter 7. It's the nuts and bolts chapter 7 bankruptcy training that's on our website, as well as like an intro to foreclosure training as well on our website. So you are free to watch those two trainings to get an understanding of chapter 7 by itself, and then a foreclosure training to get an understanding of foreclosure if those two areas are new to you. So these trainings are listed as MVLS trainings. They are pre-recorded trainings on our website. I can put our website into the chat, so you know where to go to pick up these, where you can go to get the resources for this. All right. I think those are all the questions I have seen.
All right.
So far.
I'm really glad that everyone came out. I hope it was informative. Again, don't hesitate to ask me any questions. I'm happy to answer any questions that we have. Also, if you are members of the private bar, there is a consumer bankruptcy section for the MSBA that you have to pay. That you get one free section with your membership. So if you're interested in starting a bankruptcy practice or expanding a bankruptcy practice, that's a good way to learn the basics. And also you have access to our listserv, which allows you to ask questions of people that make my bankruptcy knowledge look like elementary school. So some of the smartest people I've seen. So it's a good use of your time if it's something that you want to do.
All right, so thank you everyone for attending MVLS's third Thursday training about foreclosure and bankruptcy. Again, all of our trainings are on our website. If you have any questions, you're definitely welcome to reach out to Mr. Steinwedel or myself. And I hope you all have a good rest of your day.
Thank you.
All right, thank you.